you've just touched on the Charter of Fundamental Rights, and which won't be part of the EU law. And I wonder if we could just, on the record, hear a little more about whether you think that this will weaken the rights protection once we don't have the Charter. Do you think it's important?
I think undoubtedly it will, and I think it will do so in two main ways, and others may have points to add. But I think the two key issues will be that substantively, of course, the Charter covers a wider range of rights than the European Convention, and so it reflects the European Convention on Human Rights insofar as the rights overlap. Although even in respect of some of those rights, the European Court in Luxembourg have interpreted those rights in a stricter way than the Strasbourg Court have. There are examples of that, and but then it covers a wider scope of rights, and so you have a whole range of social and economic rights, such as worker protection, environmental protection, and so on, that are not there in the Charter. So that's one point. And the second point is that, of course, where the Charter applies, then the remedies which EU law gives right to. So if there's a conflict between domestic primary legislation and the Charter, then the courts must disapply the primary legislation, whereas the same is not true in terms of the remedies are not as powerful under the Human Rights Act. And so if there's a piece of primary legislation that contradicts the Convention, then, of course, the courts will endeavour to interpret it consistently, but if they can't, they are restricted to a declaration of incompatibility, and then it's back to Parliament to remedy it if Parliament chooses. So there's a disparity in terms of the force of the remedies. So those, for me, are the two key points, but I think there will be a significant deterioration in human rights protection once we lose the Charter.
Pretty clear.
I again agree with Murray, just picking up the point that the other issue of the Charter has the same legal status as the treaties under Article 6, subsection 3 of the Treaty on the European Union. And the case law of the Court of Justice has said that clear and unequivocal provisions of the Charter will have direct effect against private individuals just as much as against public authorities. So that will be lost, because at the moment the Human Rights Act applies only in relation to public authorities or private individuals carrying out a public function, whereas the Charter, potentially elements of it, were universally applicable no matter against whether it's a private body or not. And again, picking up on what Marie has said, having two human rights courts, European human rights courts, at some levels you think, well, that's a potential for chaos, and wouldn't it be much easier if you've just got the European Court of Justice underneath the auspices of the European Court of Human Rights? But in fact, what has happened as a result of the Court of Justice saying that that wasn't compatible with EU law is that, in a sense, there's a competition between Strasbourg and Luxembourg as to a race to the top in terms of increasing human rights protection. So if one court isn't so good on a particular area, then the other court might take up the baton. So there's a dynamic going on in that way. And again, that will be lost if we no longer are under the auspices.
I think, again, I'm going to agree with Aidan and Marie in terms of the tools that are going to be open to people who are seeking to enforce their individual rights. In cases where EU law would apply, there will be simply fewer tools in the toolbox the day after exit day. And the tools that are left in the box, as much as the HRA is significant and important, may be less effective. So I agree with Marie and Aidan. In terms of cases where EU law applies, individuals won't be able to rely on the provisions of the Charter which aren't duplicated in the European Convention on Human Rights. Where the rights that are protected by both the Convention and the Charter are better protected by the Charter, individuals won't have the benefits of that additional protection. They won't have the benefit of the better remedies afforded when you can bring a Charter claim, i.e. challenging incompatible provisions of primary legislation and asking for them to be disapplied. And finally, they won't have the recourse of going to the Court of Justice, the European Union, asking domestic courts to make a reference and asking for a final say on what the Charter really means for the protection of human rights across Europe. And what we've learnt in a number of cases is that that backstop of asking for the opinion of the Court of Justice of the European Union can make a real difference. You only have to ask Mr Watson about how his claim in respect of the Regulation of Investigatory Powers Act went domestically and how it went when they managed to get their claim before the Court of Justice of the European Union. So I think, yes, it will make a significant difference.